Anyway, the real reason that we're here tonight, it's just a wonderful example of how this law school is at the center of critical, important issues of the law. You'll be hearing and then engaging, I hope, yourselves in the conversation about critical issues relating to human capital, intellectual capital, human capital, intellectual assets, and also the challenges of public transparency and accountability. I really wish I could be here. I know that I have so much to learn about algorithms. It kind of hurts my head a little bit. So the second panel, I have 2 or 3 other events, including the State Attorney General is going to be here, and the Historical Society is downstairs. So I'm going to have to run off before I get further educated. We're very proud of the Trade Secret Institute, and this symposium is a wonderful example of how vibrant and as successful it is, and it really is something that helps position our students for the job market, for the legal market, not as it was, but where it's heading, and it's just a critical aspect of the pathway to professionalism that we're trying to promote here. The Trade Secret Institute was founded. It's the first student-led trade secrets institute at a U.S. law school, although others have followed suit now, and it's here in large part as the brainchild of a Troika Court of International Trade Judge Claire Kelly, who is a former student, professor, judge, and now teacher and member of the Board of Trustees, my boss, in other words. Alex Kaplan, a partner at Proskauer Rose, and David Mitnick, founder and president of DomainScape. I didn't see David here when I came in. Is he here? Or just give him a shout. Well, somebody tell him we gave him a shout out. And so we're very grateful for their leadership. Also, Professor Chris Beecham is taking over the reins and is providing his effective stewardship and supervision to this wonderful endeavor. And as you know, Professor Beecham is not only an outstanding professor and teacher, but he's a wonderful author of terrific books, and his field covers the area of intellectual property and legal history, so it's a very, very good fit. We're very grateful for the funding of the May Foundation that makes this all possible. And again, this is a platform that is really like no other that's available. The content that TSI provides is curated by the TSI Fellows, and it's Lauren Rayner-Davis who's right here. Your note is about the topic of the first panel, isn't it? Okay, so you guys better be on your toes, because she knows what she's talking about. And so that's wonderful. Where did you do your undergraduate work?
University of Southern California.
Oh yeah, USC. And your field was?
Back in the day, it was theater and education.
Right. You had something like 75 productions. You were a producer.
Mm-hmm. Yes.
So another thing I don't, even though I'm a big fan of entertainment and theater, I have no idea what a producer does. In fact, I don't think anybody really knows what a producer does. But sometime, if we have a chance, I'd like to you'd like to explain to me what your work involved as a producer. So we're very fortunate to have you as a fellow. Also, Christopher Aranguren. Where's Chris? There he is. I know from the classes that he was in, he's one of our leading students here, a fantastic student. And you have a science background, right? A BS?
Yeah, computer science.
Yeah.
I was running the as well.
Yeah, so you've really followed up. And then Brian Kim. And Brian Kim, you had a BA in economics, right? But then you cured that with a BS in biology. All right, but first at Emory and then at Georgia. So it's also a particularly good fit. By the way, some of you may know that we are, in addition to the LSATs, going to be considering students with GREs. And part of the reason is that demands and talents that are required in the new world of law, not for everybody, and certainly the humanities and English and economics and history are as important as they ever were, but they're also very, very important for people who have STEM backgrounds and have scientific backgrounds. And we already have many students who have depth in that field. So we're terrific, and we're very grateful to have you all working as fellows and contributing to the success of this program. Our panels are full of experts. They'll be properly introduced very shortly. And I should also thank our co-sponsor, the International Intellectual Property Society, and welcome to the IIPS members who are joining us this evening. Who are the IIPS members who are here? Maybe just raise your hand a little bit so we can see you. Thank you for being here. And I hope that you actually, if I ever stop talking, have a chance to not only hear this program, but engage and offer your insights. So, Brian, I think you have a few words to kick off here.
Thank you, Dean Allard, and thank you everyone for joining us this evening. My name is Brian Kim, and I'm one of the TSI Fellows this year. On behalf of myself and the two other fellows who will be moderating the panels this evening, we would like to welcome you to our symposium, Keeping Secrets from the Public. As a logistical note, for those who are here for the CLE credits, please make sure you have signed in the back. And when you sign out, please make sure to submit the CLE evaluation forms. Also, you have to stay for both panels to receive the CLE credits. The mission of the Trade Secrets Institute and the goal of the symposium is to explore trade secrets protection. TSI provides reviews of key trade secrets cases and legislative initiatives throughout the United States. Our institute, through the work of the fellows, provides content through its online database, which is the first of its kind in the nation. You can check out our database at tsi.brooklyn.edu. Along with the reviews of the trade secrets cases, you can easily access relevant court documents, legislative materials, and original commentaries. We also tweet and about news coverage about trade secrets cases. You can follow our Twitter at Brooklyn Law TSI. 2017 has been a breakthrough year for trade secrets law. We saw the first jury verdict under the DTSA, which is short for Defend Trade Secrets Act. DTSA's controversial ex parte seizure was used to broadly seize all electronic memory devices of 2 ex-employees of a company in Oklahoma. There were also many high-profile cases in 2007, including the battle between Waymo and Uber. I'm sure many of you know about this case, but for those who don't, Waymo is a subsidiary of Google for self-driving car technology. And Waymo alleged that its ex-employee downloaded thousands of confidential files before he left and started his own company. The case was also referred to the U.S. Attorney's Office for potential criminal investigation. Regarding the civil side of the dispute, it was actually just settled last week. There were also criminal cases related to trade secrets. In People versus Alinikhov, the Second Circuit U.S. Court of Appeals reversed Sergei Alinikov's conviction for stealing proprietary computer code belonging to Goldman Sachs. Also last year, Dmitry Sazonov, a software engineer, was charged with attempting to steal trading code from his employer, Susquehanna International Group in Manhattan. In our first panel, the panelists will discuss how the new DTSA have impacted the trade secrets landscape since the law became effective in May of 2016. They will also discuss the interface between civil and criminal actions for trade secrets misappropriation. With that said, I'm going to hand it over to Lauren. Thank you.
All right. Thanks so much, Brian, and thank you to Dean Allard for the warm welcome earlier. I'm thrilled to introduce our esteemed panel today. Kenneth Corsello on the end there is the IP Law Counsel for IBM's Watson Customer Engagement Business Unit, and he is also chair of the Intellectual Property Owners Association's Trade Secret Committee. Victoria Cundiff, next to me, is a partner at Paul Hastings here in New York, where she's the leader of the firm's nationally ranked global trade secrets litigation practice. And she's also a visiting lecturer at Yale Law School, where she teaches IP law, and at the University of Pennsylvania Law School, where she teaches trade secrets law. And Alexander Southwell, here in the middle, is a partner in Gibson, Dunn & Crutcher's New York office, where he is chair of Gibson Dunn's Privacy, Cybersecurity, and Consumer Protection Practice Group. And prior to joining the firm, he served as an assistant United States attorney in the United States Attorney's Office in the Southern District of New York. So now let's jump right into our discussion and why we're all here today. As Brian just mentioned, in May of 2016, President Obama signed the Defend Trade Secrets Act into law. And this was a bill with near unanimous support, bipartisan support. And for the first time, the DTSA provides a basis for original federal jurisdiction for private civil actions alleging trade secret misappropriation. Now, 3 years ago, this symposium discussed early proposed versions of the DTSA before it was passed, but now that the law has been invoked by litigants and interpreted by courts for almost 2 years, we hope to investigate a fuller picture of this unprecedented legislation's effect on trade secrets law with our panel today. So with that, the first question is for all three panelists. Some of the predictions regarding the DTSA's impact on the trade secrets landscape have not necessarily turned out as expected. What do each of you feel are one or two of the most significant recent developments in trade secrets law since the DTSA's passage?
Well, I might jump in, and I'd very much like to thank you all for inviting us, and I'd like to give a big shout out to the Trade Secrets Institute. Your work is a very, very valuable resource to practitioners, to students, and I understand to courts as well. So thank you very much for giving that to us. I know it takes a lot of work. So to take just a couple of minutes to put the Defend Trade Secrets Act into perspective, trade secrets law has been a fixture of the American legal landscape for many, many years. New York has long been a leader in generating thoughtful trade secrets decisions, influencing and being influenced by the Restatement of Torts, which was issued in 1939. Since then, most other states have adopted the Uniform Trade Secrets Act. At this point, only New York and Massachusetts have not. The Economic Espionage Act, a federal criminal statute to protect trade secrets, was passed in 1996, and discussion about whether there should be a federal civil statute began that very same year. So for the past 20 years, there's been discussion about whether there should be a federal civil trade secret statute. In New York and many other states, there's been a lot of trade secrets litigation in federal courts under diversity jurisdiction where possible, or ancillary jurisdiction. But after many years of discussion of what a federal statute might look like, it was finally passed in 2016. And I think that the clearest impact of it is that the run-up to the statute generated a great deal of focus on trade secrets issues. The statute itself introduced some nuances into protections for trade secrets and also protections for trade secrets litigants. From a pleading standpoint, it's hard to tell exactly where the law is shaking out here. We understand from the Federal Judicial Conference that roughly 1,000 cases have been filed in the first year or so, well, since last May when the act was enacted. It's now, cases are now being filed in federal courts at about the rate of 60 per month. We don't know what's happened to state court trade secrets litigation because it's hard to do the empirical research, but many cases are still being filed in state courts. I think some sound bites that I would mention is that now it is possible to assert a trade secret misappropriation as a RICO predicate offense. That means that there have been more RICO cases filed. But we need to put that in perspective. There had been RICO trade secrets cases before, every few years. Now there have been about 15 or so since the passage of the act. None has gone through to conclusion, so we don't know what the impact of that tool will be. It's very hard to prove a RICO violation because you have to be looking at multiple offenses. I think we now have the ability to seek ex parte seizure orders to prevent the dissemination of trade secrets. This was one of the most hotly debated areas of the new legislation. It has not been used to any significant degree. There have been approximately 18 requests for ex parte seizure orders. Approximately 6 have been granted. I think that the rigor that was put into the statute in terms of what you have to show to get a seizure order has meant that people think long and hard and carefully, as they should, before seeking this relief. And finally, there are some interesting issues that we'll be talking about through our panel that haven't yet been litigated, but I think we can predict will be. There's a driverless car case going on right now in China that very much mirrors some of the accusations that were made in Waymo against Uber. Under the Defend Trade Secrets Act, if an act of misappropriation took place inside the United States, trade secret owners can sue here. So it'll be interesting to see whether non-U.S. plaintiffs start availing themselves of the DTSA here.
Yeah, I agree with you, Vicki, that the increased focus is probably the biggest effect of the DTSA. I don't actually think it was expected to be a major change by those who followed it closely. It's very similar to the Uniform Trade Secret Act, but probably because people didn't follow it closely, they said, oh my gosh, now there's a federal trade secret law. So there's been a lot of programs and CLE classes about it, and that has had the effect, I think, of companies thinking about, in-house attorney at IBM, companies thinking about their own, how they protect trade secrets. Typically, I'd say at most companies, there really isn't a trade secret program. For patents, another branch of intellectual property, there's a much more formalized process. Trade secrets, essentially, you must take reasonable measures to keep them secret, and they must have value by their being secret. So people basically put up measures to keep them secret, and then they don't really often think about them unless and until there is a misappropriation or a fear of misappropriation. But it isn't just the Defend Trade Secret Act that's done it. You have it's just become easier and easier to steal trade secrets. It used to be you needed a truck to carry out all the goods. I saw the movie The Post recently. I don't know if you saw that movie about Daniel Ellsberg had to steal the papers in he had to keep them out day by day. He took all the Pentagon papers. Today, it's just a thumb drive in your pocket, and you could take who knows how many things. And there's been a weakening of the patent system over the past decade. We'll debate about whether it's a good or bad thing, but there's definitely certainly a perception of that, and that has caused people to focus more on trade secret protection. Although I think to a large degree that's a little bit of a false choice, because the main consideration when you're deciding whether to keep something secret or file a patent application is the nature of the information, and if you were to commercialize it, is it going to be known anyway? Can people reverse engineer it? Or oftentimes, when you sell a product, they'll be able to tell the service, they'll know anyway. So there's no point in trying to keep it secret. And conversely, if you file a patent application on something and you can't tell if anyone else is using it, that's basically just giving away your secret, and because you'll never be able to prove that anyone is using your patented idea in that kind of a scenario. But there's a lot in the margins and in the middle, and that's where you think about the fact that patents are weak, and in particular the subject matter law of patentability has contracted the scope of patentable subject matter in computer-related technologies and in biotechnology. So I guess I also wanted to mention, in terms of developments, you have the European Directive on trade secrets requires it was passed in 2016 May, requires all the member states, 28 member states of the European Union, to meet some minimum floor in their trade secret laws, to have trade secret laws that meet minimum standards, and there's some maximums they can't go beyond too. But those countries are going to have to enact such statutes, such changes, if necessary, by June of this year. So far, no country's done anything. They could take the position, and some of them would be, legitimately take the position that, well, their laws already comply with this. I know the UK has, so that, of course, they probably don't have to comply because they're leaving the European Union. But that's one thing I wanted to mention that people should watch out for over the next 4-6 months, I guess, 4 months. And the other item I was going to mention is there was announced, the U.S. government has announced an investigation of China for violation of, under the so-called Special 301, a trade-related statute. And part of that is the allegation that they have forced U.S. companies to divulge trade secrets in order to do business in China. And I think over the next few months, we'll see what the administration does, given all the, the attitude of the current administration to international trade and to in particular, China and such. They may take a pretty aggressive approach, and they could, China probably could, complain to the WTO, and could be a big thing if that all happens.
And I'll just add a quick comment that I think one of the significant issues here is sort of the overarching importance of the digital economy. I mean, the information is increasingly valuable assets of corporations in the United States and globally is increasingly intellectual property. And it's how do you protect that intellectual property from espionage by competitor companies, by countries, disloyal employees. And so the emphasis and the focus on trade secrets, trade secret protections, I think is driven largely by that being a really significant driver in the economy. It's not so much that it's driven by the DTSA, but the DTSA is a reflection of the fact that these issues are so paramount. And so it is the protection of those assets, the protection of the value of those assets that becomes important. What the law provides is more options to protect those assets or to pursue those, who are believed to be, taking assets. And so, the economic, the DTSA modified the Economic Espionage Act, which has been in place as a criminal statute. When I was a federal prosecutor, we used it with some regularity, although it was not used with the same regularity that it is today. It was the kind of statute that was used every once in a while, but today there is a sort of a steady drumbeat of both criminal cases, typically involving foreign nationals and stolen corporate secrets. And I think that the fact that there is now a federal civil option to pursue those cases really just increases the menu of available options for practitioners and companies who are looking to sort of defend those assets. And I think one of the other comments is that the trade secret law is really, the law didn't substantially change. So it's not a legal distinction, it's more of an option of where you want to pursue it. The cases are really highly fact dependent. It's all going to depend on, what exactly happened. What was that employee putting in their briefcase when they were getting on the plane to Beijing, right? What were the events that surrounded their access in the computer network at 2 in the morning, when they were, in some remote location. Those kinds of the issues, and we'll talk a little bit more as the night goes on about some of those more nitty-gritty, issues in terms of the practice of investigating and pursuing trade secret claims.
And I just wanted to mention one point that's embedded in what we've all said, that I like pointing out that it's a new option. It didn't take away any options. So you can go to state court and bring claims under state laws, and in some states and with some courts, that's exactly what you'd want to do. There may be longer statutes of limitations, there may be greater availability of punitive damages, there may be a faster court pace. So it's additive didn't subtract anything.
Yeah, although I will just note that, I mean, historically, state courts have a slower pace than federal courts, perhaps. And so, particularly New York. And so the option of a federal court and the ease of accessing a judge who's going to, hear preliminary relief applications is a substantially, in many cases, a substantially better option.
Yes, wonderful. And while the DTSA is quite important for all the legal practitioners here to know about and all these other significant developments that were just mentioned, there have also been some recent trade secret developments here in New York State. And Ms. Cundiff, in one of our earlier conversations, you mentioned a Second Circuit case, E.J. Brooks Company versus Cambridge Security Seals. And this case has been referred to the New York Court of Appeals for determination of New York's view of what damages would be available under an unjust enrichment theory. And I was hoping, Ms. Cundiff, you could kind of describe what's at stake in this case.
Sure. So it's interesting, in discussing trade secrets law, we always spend a lot of time talking about the DTSA, the Uniform Trade Secrets Act, and then there's New York and Massachusetts, which have not adopted the Uniform Trade Secrets Act. And so that means, for example, that absent other theories, there is not an entitlement to attorney's fees in New York. If you prevail in a trade secrets case under the Defend Trade Secrets Act, that is an option. And another difference is that under the Uniform Trade Secrets Act and the Defend Trade Secrets Act, there are basically three buckets of damages that you can recover for misappropriation. Your lost profits, in part because many trade secrets cases are brought before the owner of the trade secret has really been able to get up and running and made a lot of profits. There's also the possibility of getting the gains that the misappropriator received through the misappropriation, or maybe the misappropriator is able to sell into different markets from where the trade secret owner was able to do so. So lost profits, the profits of the other side, or unjust enrichment damages. And unjust enrichment can include the development costs. So you spent $1 million developing your secret process, somebody stole it, you may be able to recover $1 million under the Defend Trade Secrets Act and under the Uniform Trade Secrets Act under the unjust enrichment theory. Well, it's not so clear that you can recover the avoided development costs in New York law. There have been some cases that have permitted it, but it's been under theories that were really specific to the particular case. So sometimes the misappropriation has been engaged in by someone who was in a fiduciary relationship with the trade secrets owner, and so there is past case law saying, well, there was basically a relationship of trust. A trust was created for the benefit of the trade secrets owner, and part of what's in that trust is the development costs, which need to be repaid. In the E.J. Brooks case, the plaintiff was not able to establish lost profits because the defendant, who was found liable for misappropriation, had not diverted plaintiff's customers. Apparently there were discovery issues, and so it was very difficult, if not impossible, to calculate how much money the defendant had made. And so there was testimony at trial about here's how much it cost to develop the trade secrets, and that's the amount that the jury awarded. The Second Circuit, in reviewing this, said, yes, but I see what you're saying about the case law under these other statutes. We don't have that statute. And does there need to be a relationship between the development costs and what the plaintiff lost by way of sales? And so the court said, for example, the trade secret owner still retains the benefit of the development costs. Should the trade secret owner be able to recoup all of the development costs that were diverted through the misappropriation? The Second Circuit says, we don't know. It's a state law question. They've sent it over to the New York Court of Appeals as a certified question, and we'll know more if we have another session like this next year. But it does show the importance of recognizing that there are different approaches depending on what the Court of Appeals decides, it may be that litigants in New York will want to rely on the Defend Trade Secrets Act where this remedy is clearly available, or they may reach some other conclusions depending on the decision. So again, it talks about options.
Right, wonderful. And as a follow-up to this damages discussion, a question for all of our panelists, how do litigants and courts, for that matter, quantify what trade secrets are worth? And I was wondering if any of you had any opinions on whether the DTSA has had any impact on whether or how damages are sought.
I'll start with a comment that in large part, damages, well, in many cases, damages are a subsidiary question to injunctive and equitable relief, which is what you may want to seek with, a greater urgency, right? If somebody has taken a trade secret and they're about to launch a new product, right, they haven't actually sold the product yet, there may not be damages. Really what a party would be seeking is injunctive relief, declaratory relief, or something along those lines. Damages doesn't even really enter in. I mean, of course, everyone puts in the claim for damages for many millions of dollars, but it's really the battle's often about injunctive relief. And so that's often where these cases are litigated. The other aspect, I think, on damages that's interesting to note is that because what we're talking about is, intellectual property, and it can be incredibly valuable, the cases get they're a little bit odd in that you can get incredibly outsized damages figures quite easily. And this comes up in both the civil and the criminal context. And when I was a prosecutor, I prosecuted a famous case called United States versus Genovese, where a guy was selling a stolen copy of the source code for Microsoft Windows, right? So you think, all right, and so for his sentencing purposes, you have to value that property. Well, it was the source code for Microsoft Windows. Microsoft Windows is the best-selling product ever for Microsoft, and it makes them probably, $1 billion a year or some absurd figure. And the point is, if you do a traditional damages calculation, you get a figure that's in the many billions of dollars. And because of the nature of intellectual property, you can get damages figures, really big, really fast. And that raises an interesting specter because, at least in the criminal realm, unlike in the civil realm where you want to have a big damages figure because you're probably going to settle it and you can use that for leverage, in the criminal realm, you have a judge who's going to consider the question of whether that's an appropriate figure, and the assessment is a little bit more nuanced. And frankly, the judges don't always appreciate somebody claiming an astronomical figure because it goes against their sense of justice. And in that case, we actually came up with an alternative damages figure because we knew if we argued that the judge should find $1 billion of damages, the judge would frankly be annoyed, and we would undermine our ultimate goal of getting a jail sentence for this individual who was a repeat cyber offender. He had had a prior, criminal hacking conviction, and so our view was that he needed to go to jail, and to argue for billions of dollars of damages would have undermined that. So we came up with an alternative method. And so I think the damages questions in this area are often challenging, sometimes require some creativity, and always interesting, I suppose.
You wanted to know how we quantify how trade secrets are worth. Well, it depends on if we're the plaintiff or the defendant. For the plaintiff, whatever gets us the most, and the defendant, whatever's the least. We're not in litigation, trade secret litigation that often, and as far as the trade secrets that we have within the company, we don't value them really, they just are. We don't spend any time looking into it.
And it is interesting in the civil side as well. These outsized verdicts are the ones that get scrutinized the most on appeal.
Yep.
And there have been some trade secrets verdicts before the DTSA that have been in the $1 billion range, and they've all been cut back. But hundreds of millions are still a lot of money as well. But and you also often see this dueling in the Waymo against Uber case. Waymo's expert was saying the trade secrets at issue were worth $1.6 billion. Uber's expert was saying they were worth at most $600,000. I think that we will see greater focus on some methodology for valuing these in litigation. To Alex's point, mostly the focus has been on injunctive relief. Through the ability to conduct forensics inspections, you may be able to learn more than ever before about how the trade secret was actually used. And so you may find that you were damaged in ways that you weren't able to figure out before. So we may be seeing more damages cases, and because of some developments in the availability of equitable relief, we may find more cases where courts are saying you don't get your injunction, you will get damages. There's a lot of work to be done, and particularly in the trade secrets area.
So just to change gears here a bit, but related to the onslaught of legislation that the DTSA was expected to bring, in recent years, as Brian mentioned, we've seen some civil cases take a dramatic turn into criminal investigation and even aggressive prosecutions. Some of these investigations include the Waymo Uber case, which Brian mentioned just settled last Friday, February 9th, the Lenyakov Goldman Sachs case, and then the DuPont Colon case, and many of others have garnered national attention and press coverage. Mr. Southwell, as a former prosecutor turned civil litigator, do you see a trend here? Or put another way, do you see a meshing of criminal and civil enforcement? And also, just for our audience, how does that process typically work?
Yeah, look, I think it goes back to what I commented on before. It's a reflection of the importance of the digital economy. The federal law enforcement in particular has emphasized the importance and prioritized the protection of intellectual property. It's sort of cyber crimes generally, which include that, is the number 3 priority of the FBI behind counterterrorism and counterintelligence. And it's because of the importance of it to the economy. And when you have law enforcement that emphasizes the importance of these issues, then resources are dedicated and more cases are brought, more investigations are open. Now, the investigations occur in a variety of ways, right? So the investigators can open a case because they get a tip from the public, because they observe something, because they pick up somebody on some other issue and they flip and they tell them about something else, or because a company reports an issue and there's what we refer to as a criminal referral. And that's probably in this space the most common way that these cases come up. And so it is one of the options in the arsenal of a practitioner when I have a client who comes to me and says we have this problem of we believe that some trade secrets have been exfiltrated. We don't know exactly how it happened. There was a network security issue. What happened here? Or they have an employee who has been doing something a little suspicious and they've just booked a last-minute trip to Russia. There are things like that cause companies to say, what are my options? And so we often talk to those clients about those options. And so the options are civil action, criminal referral, or sometimes both. And you typically don't want to do both because when you're asking a criminal prosecutor to start an investigation and devote resources, they typically don't want to have the potential interference of an ongoing civil litigation. And that's for a number of reasons. Number one, they have limited resources and they view it as if you're a party that can take care of the problem for yourself through civil litigation, no need for us to devote resources. It also is because if there is ongoing civil litigation, it leads to civil discovery, and perhaps the witnesses that the criminal authorities would want to rely on are going to be deposed in the civil action. It gets messy. There used to be a trend of staying civil cases during the pendency of the criminal cases. This occurred a lot in the securities enforcement area, and increasingly judges are refusing to do that, and so there's an ongoing civil case at the same time as a criminal investigation. That gets really messy. So prosecutors don't generally like that. They like, if you're going to bring a criminal referral, they like you to bring the information to them and let them investigate. From a company perspective, there are a number of aspects to that. Often, you can't control when the criminal prosecutors are going to bring the case or even whether they're going to bring a case at all. So you have to make a judgment call about whether this is significant enough to warrant interest, that they will open an investigation and act promptly. The way that when that comes about most often, quite frankly, is the situation of the employee who's booked the last-minute flight. Typically, it's to China. Those are the cases that typically have been prosecuted. There were, 13 criminal cases under the Economic Espionage Act last year, and one of the primary motivations for going to the criminal authorities is that they're the only ones that can get on the airplane and pull the person off before it takes off, right? They have the power to arrest somebody before they leave the country. And so when those facts are presented, that becomes a more important reason to go the criminal route. If you have more traditional cases where you're not quite sure what happened, or an employee left and there was, a founder's dispute and somebody left and they started up a competing app that sort of does the same thing, those cases, you can bring to the criminal authorities in the same way, but they're often messy. And there is a general view of law enforcement that they don't want to get involved in kind of messy civil disputes. And frankly, as part of the referring matters to law enforcement, what you want to do, ideally, is wrap up the case in with a little bow. You've explored it all, you've figured it out, you hand it to them, they're ready to go. Well, that's not always possible with these kinds of cases. You don't exactly know what happened. You get an alert that there's some suspicious activity. Somebody decides they're going to leave, and you hear, from somebody that they're starting up a competitive company, right? But you don't know all the facts initially, and so it's also a question of what are the facts that I know and I can rely on, and that will lead to sort of judgments about which way I go between criminal and civil.
You mentioned the person getting on the plane. That sounds like what the ex parte seizure provision of the DTSA was about. How would you compare the two? I mean, I know there aren't been many of those.
Yeah, I think that's a really interesting aspect, right? So the ex parte seizure order, in some ways, is intended to replicate what the criminal authorities can do, what the FBI can do to seize items. And it actually is modeled under a somewhat existing space in the criminal copyright area, or where people can sort of go out and get seizures of,
As a matter of fact,
container ships.
The marshals would be ordered to carry out
Yes.
the seizure in the DTSA.
Right, and so it is essentially the civil ability to execute a search warrant the way that the criminal authorities do. One of the other aspects of bringing a case to the criminal authorities is you don't control what they do, right? They will either take it slowly, they'll take it quickly, they might turn their spotlight to you and your conduct, they might question, whether you were really protective of things. I mean, there's a lot of wild cards that go into that. And so I think the ex parte seizure process was designed to give parties that were aggrieved some ability to very quickly go in and get action in this scenario where you have strong evidence somebody's about to flee. Now, there is other injunctive, there are other injunctive relief rules and modes through the federal rules that are available. You don't need to just use.
And as a matter of fact, I think, Vicky, you'll confirm, that's mostly what judges have ended up doing
Right.
in those cases.
Yeah, and they're because they're used to it, and it's more
Yes.
comfortable, and it's less of this kind of scary ex parte
Well, and ex
quasi.
parte smacks of potentially being unfair.
Yes.
And courts don't want to be unfair. They, in most cases, unless the person is really on the way to the airport,
Right.
they want to hear something from the other side. But in certain cases, you can lay it out. Here's why there shouldn't be notice. The person is headed to the airport. There's reason to believe that they're uploading things to the cloud or that they'll destroy it. But in the thinking through what the ex parte process looks like, a lot of procedural safeguards have been built in. If this is what you must show, since it is ex parte, since the other side doesn't get to respond, the burden of proof is on the plaintiff. They have to satisfy to a very high standard that they have the proof that they're alleging, and the plaintiff can be forced to pay significant damages if they're wrong on this. So it's vesting private parties with some of the awesome power that the government has, but at a price.
Right, and I think that's partly why it has not been invoked that often, because it is a really sort of dramatic step, and you have to have a really strong showing. And quite frankly, if you have that strong showing, it may make more sense to go to law enforcement, because there certainly is a lot of law enforcement interest in the area, and you know, part of the calculus of that is where do you bring a referral, who do you talk to, and you know, there are certain offices that are more interested and others that are less, and depends on the jurisdictional issues. There's lots of factors that go into that kind of a calculus, but I think that because the standard is so high for the ex parte seizure orders, I think it's going to remain the case that it's fairly infrequently sought or obtained.
I like what you said, Alex, about turning the spotlight back on you. I know our executives would be worried if the prosecutor came in and started investigating, what else would they find?
Yeah.
We don't have anything to worry about at IBM, but I know a lot of companies would think about that.
It is a natural reaction.
And what if contributors to the IP at issue, maybe they brought it from someplace else?
Yeah. Because you don't really know, until you start spending a lot of time figuring things out.
Yep. Yep. And quite frankly, I mean, in trade secret cases in particular, one of the things prosecutors have to prove is that you were careful and you protected the trade secret. So there is an element of, did we do a good enough job in protecting the trade secret, that is part of a case. And that is turning the spotlight on your own activity. So part of the calculus, frankly, in bringing a civil case or a criminal referral is, can we make a good showing that we were careful? Or are we going to be exposed as having been kind of sloppy? And you know, that may enter into a company's decision to say, I'm not going to go public with this because we're going to be exposed as sloppy and we're going to look like we're not on top of things, and that's going to hurt our business. All of those kinds of things go into counseling clients through these issues.
You know, it does seem that the availability of criminal sanctions has led some organizations to make sure that they're counseling their employees well of what happens. Your employee gets an offer from somebody who says, hey, I can give you the Coca-Cola formula. You want to make sure that your employee knows not only to say no, but how to report it internally. Yeah. And so there have been a lot of training programs around that.
Yeah, and that's actually an excellent segue into what I was hoping we could tackle next, which is kind of the in-house counsel perspective here. So, Mr. Corsello, what practices do you think are most effective in enforcing corporate trade secret rights while still balancing the rights of employees, especially with regard to potential for criminal liability?
Yeah, well, I think the most important thing is your culture, the culture of your company. There's a phrase, culture eats strategy for breakfast. And that's thinking about, winning business, but it's also very telling as to, keeping your information secret. You want to have your employees respect. You want to have, respect for each other and respect for the intellectual property of other people. And you could see, for example, in the Uber case, they were really put on, Waymo was trying to put their culture on trial, put the Uber culture on trial. The judge was trying to prevent that, make it a debate about trade secrets.
There were some ample, perhaps, anecdotal evidence that was helpful for them.
Yeah. So I think that we have annual certification at IBM. Each employee must certify to our business conduct guidelines, and one of the aspects of that is that they respect the intellectual property of others. As a matter of fact, I just, dealing right now, I've asked some developers to transfer some code. We've asked them, and they won't, to basically, so to say to a third party, and it has some, copyrighted content that's owned by a different party, and they won't do it. And I'm just telling them, no, we have the right to do it, but they still don't want to do it. Because we shouldn't do this. They're just so trained not to copy other people's intellectual property. So I think that's the most important. Now, of course, you have other, there's exit interviews because many of the trade secret misappropriations stem from employees. Sometimes at the company, or will often leave when they leave the company. So we do exit interviews for all employees, but they don't all have a heavy emphasis on a trade secret concerns, but if the person has access to particular information, or if they, are at a particular, going to a particular company that we're concerned about, we will have an attorney interview them and, talk to them particularly about that. We had a criminal violation. It was probably 10 years ago. Someone from IBM left and went to another company and gave them hey, here, this is going to be helpful, right? And that other company did the right thing. They actually referred to the prosecutor, or someone did, and they indicted the person and they settled the case. They put out a press release. So I have a copy of that press release, and I'll say, by the way, as you might want to take a look at this, just to read it, just to know. So those are some of the things. I think you talked about risky hires. Is that something you wanted to get into?
Yeah, no, I think that would be great for all panelists to discuss, and just given the impact of these high-profile cases.
I'll just say we pretty much, at my company, we wouldn't have a risky hire. We just wouldn't hire that person if they were too risky, but that's not always true. I don't know if you've seen other things, Vicky or Alex.
Yeah, I know. Look, I think this is where a lot of the activity is in this space. I think oftentimes it comes up with, highly aggressive competitors, people leave, emotions are charged on probably both sides. Sometimes you've got the issue where somebody has left and they've taken like highly technical, drawings, clear sort of trade secret type drawings. I think those cases are fewer and fewer than the cases about the sort of the know-how in the mind or the customer list or the business strategy. And those often present more nuanced, more, closer calls about whether it is a trade secret. And as a general matter, I think companies need to be extremely careful about bringing people on. And it is a delicate dance because, sometimes you're trying to recruit somebody who's resistant and you're trying to sell the person and you're trying to sell them on the benefits of coming to the company. And that's not always consistent with the notion of, we don't want you to take any, information, right? Because oftentimes the value they have is the years they've spent developing some self-driving car or some new, pharmaceutical, process or whatever it might be. And I think that companies just need to be incredibly careful. And so there's sort of the recruiting process and then there's the onboarding process. And if you haven't been as careful in the recruiting process, you've got to be a lot more careful in the onboarding process and make it crystal clear what your expectations are. You have clearly documented, signing of, codes of conduct and acknowledgements. And many companies take extra steps in those realms. And I think to have legal conscious of this and to go to the culture point to make sure it's ingrained in the thought process of the company so that if they see something suspicious about the new hire or there's just something they question, they know who to go to and who to ask.
It's also very important to remember, however, and I think the DTSA is quite clear on this, that it's not necessarily a bad thing for employees to move to other organizations in the same field of influence or the same field of activity. And people may leave for perfectly legitimate reasons. They may think it's more that the other shop is better managed, is doing more interesting things. They're dedicated to pursuing projects that the first company isn't.
They may get paid more.
They may get paid more. There's nothing wrong with that. And so employee mobility is something that many states have very explicit policies about. California essentially prohibits most employee non-competes, except in the connection with the sale of a business. Other states take some different views of this, but no state says, gee, the safest way of protecting trade secrets is to make sure that the person who knows trade secrets can never, ever leave your company. That would be a socially harmful policy. And so the DTSA actually addresses that to some extent in some of its provisions about injunctive relief, saying that the court can order injunctions to protect trade secrets, but can't issue an order solely based on the DTSA prohibiting an employee from taking employment. And it goes on to say it has a provision saying, and restraints on employment have to be supported by evidence. Well, to a litigator, that's not new. In order to win a restriction, you always had to prove why you were entitled to it. But we certainly don't want to leave people with the idea that just because somebody knows a trade secret doesn't mean that the person shouldn't be trusted to go work for a competitor. What it does mean is if you're hiring somebody who's been immersed in another organization's trade secrets, you want to be careful that you're getting the great engineer is not bringing information with him. And in the Uber case, apparently there was testimony that Travis Kalanick said to Larry Page at Google, You're upset because your people are leaving. Your people aren't IP. Well, that's a complicated statement, and sometimes the people are so embedded with IP that you have to be very careful. But it's also important to distinguish that, of course, an engineer is going to be a better engineer after 2 years working at a company unless he or she was asleep. And that doesn't necessarily mean that he's bringing you trade secrets.
Yeah, I have a quote from that case. The judge said, "Is an engineer supposed to get a frontal lobotomy before they go to the next job?" The answer's got to be no, but say they know the recipe for Coca-Cola, they have to forget that for their next job. So how do you make
But,
the
well, and in
secret?
today's sort of digital economy where, if you're working on some, self-driving cars, the reason somebody is being recruited is because they have the valuable experience of having worked on self-driving cars, typically, not because they just happen to be good at, programming in a particular language.
Right.
And so it is this tension in the law and how you assess people's motivations, and it's going to be the kind of thing that will continue to be litigated and fought over, probably ongoing.
Yes.
Could you talk a little bit about the distinction between the general knowledge you can acquire and take away with you and the definition of trade secret that would be honored now in just the context that you're talking about?
Well, that was the subject of a great deal of back and forth in the draft jury instructions in Waymo against Uber. And I have to say, as a practitioner, I'm sorry the case settled because it would have been interesting to see.
Good for the parties, but not for
Yes,
us.
absolutely right. And Judge Alsop was very much focused on this. And so in his proposed instructions, he tried to distinguish between an engineer can take engineering knowledge and even knowledge about particular projects, but he or she is not permitted to take specific information with them. And that was the task that he was going to be giving to the jury. The taking specific information, we get it that you shouldn't have a thumb drive where you bring bits and bytes over and plug it in and use it at another company, but what about the remembered information? And that's a very challenging issue. I think the court in that case was trying to focus on it has to be specific. You can't just vaguely say, oh, the person knows a lot about driverless cars, about LiDAR, which was sort of the eyes of being able to see where other cars were. You can't, that you have to be more specific than, he's worked on source code for developing LiDAR. You're going to have to be very specific in defining what he or she can't take. But it's not an easy task, and the quarreling over the jury instructions in that case certainly emphasizes that that's true.
Vicki, would you say it goes to the question of whether it's just publicly known at all? I mean, for it to be a trade secret, it has to have value by virtue of it being secret. So if this information is general knowledge, it's not going to be a secret.
But that's part of it, but I think it also, if someone could have remembered the programming of how to make LiDAR do a certain thing, like identify a bicycle on the side of the road, right? Mm-hmm. If they could actually remember that in their mind, I'm not sure there's a case that would say you cannot create that again. But the reality, I would say, is that nobody actually can remember it, so they just take it with them when they leave, right? So that factually, that's the much more typical scenario. So it's an interesting academic exercise to think if somebody didn't take anything and they just had an incredible memory and they remembered the source code that they had programmed on how to have LiDAR identify bikes, would that be?
Well, and there is some case law saying that remembered information can be protectable as a trade secret. There are cases where the person has been on the stand and he's testified, yes, I remember the formula. And presumably it's a short formula,
it's
not
easier
pages and
right,
pages
right.
and pages of formula. And there's also a notion, and New York certainly supports this, that studied memorization is a bad thing. And I always think about the Hitchcock movie where the guy had trained himself to remember the secret code to pass along. So it's not entirely clear what studied memorization is, but forcing yourself to remember long enough to run over to the other company so you can write it down, that's not good. But But you're right, as secrets become more complex, you know, are the engineers in Silicon Valley going to look at Waymo against Uber and say, okay, I get it, it's bad to do all this downloading, but if I don't download, am I safe? And that's the question that we're all going to have to grapple with.
Because I think in the Waymo case, there was no question, like you said, Alex, that he stole it.
Right.
I mean, but I think the judge was trying to put up front, is this really a trade secret or not?
And
Right.
then on some of it, the judge said that Galileo knew some of this. I don't know how the judge knew that, but.
I think we had time for a few more questions.
Okay.
Just in the front.
Yeah.
IBM used to publish their stuff. IBM used to publish their technology as a defensive matter. Do they still do that? And do they do less of it with the Defensive Trade Secret Acts being part of the value of the unused information?
Yeah, maybe some. So we publish, when an inventor discloses an idea, we can either file a patent application, or we can close it and just keep it secret, or we can publish it. And the reason IBM publishes it is to prevent anyone else from getting a patent on it. So if it's, when I'm handling those situations, if it's the type of thing, as I said earlier, that even if someone got a patent on, they couldn't tell we were doing it because it's just, by nature, you can keep it, this type of use secret, then it wouldn't benefit us to publish it. But that's a judgment call we make, and we publish them, you know, on the internet today when we do that.
Well, and I would just add a comment that I think IBM is perhaps anomalous in today's society of the sort of new tech companies who are much, much more secretive, at least generally. I mean, I think that the focus in sort of today's sort of digital economy is not revealing anything and being incredibly secretive and trying to maintain your employees. Whether that's better or IBM's approach is better is, you know, I suppose an open question.
Yes, in the back there. Sorry.
New York and Massachusetts enacted the TSA.
I think part of it is, they're both considering it, and they've both considered it a number of times over the years. I think, frankly, New York has, until recently, figured it's not broken, we don't need to fix it, we're dealing with trade secrets cases very well. I do think the availability of attorney's fees under both the UTSA and the Defend Trade Secrets Act may be an important factor in deciding to go forward. But I think both states actually have very well-developed, rich bodies of trade secrets law, and I think they've largely figured they don't need it.
Ma'am, you had a question? Or someone had a question over on this side? Oh, sure.
So you guys haven't talked about this yet, but I know that some of you have experience with financial representation and investment advisors moving from firm to firm. So how do you feel about firms withdrawing from the protocol for broker recruiting?
I'm not familiar with them withdrawing from the broker protocol. I certainly am familiar with them signing up to it. And it's an interesting way to deal with sort of soft trade secrets in that a lot of the brokerage firms realized that they were in court every week on both sides of the V. So 1 week somebody's rushing to court saying it's terrible, the rep has left and taken the customer list, it's an awful thing. Then next week they've hired the replacement from another firm and there's a lawsuit, oh, it's terrible, he's come with customer information. And so they reached a number of organizations entered into this protocol saying, let's agree that certain information is free to be taken. It's not trade secrets misappropriation. We don't want to leave the customers in the lurch. There are also securities rules that say you can't interfere with the customer's right to choose. So that's how the protocol came up. I think it might be an attractive model in some areas, in some other industrial areas. There have been cases where there's actually been much more than that that's gone on, that there's been, you know, taking of computer code, of portfolio modeling techniques and so forth. And sometimes courts have said, because you entered into the protocol, you agree that's evidence that money damages can make you whole. And so some organizations have thought, is there a downside for the true trade secrets cases to having entered into the protocol? But I'm not aware of large-scale withdrawals from the protocol, and would be interested in catching up, perhaps in a break after the discussion.
Great. I think we have time for one more question, if there was any others. All right. Well, then, thank you so. Please join me in. Oh, there's one more. Sorry.
Can you talk about the definitions of trade secrets in terms of what you have to do to keep it secret? How strict the courts being in enforcing that? Are the restrictions called for by these various laws practical in terms of how industry really operates? And can you repair not having done it properly? So if I didn't do it properly for 5 years and I start a new procedure and I do it, have I my situation? And as part of that, is a blind alley a trade secret? Drug companies go down 100 blind alleys, and that saves another drug company a lot of work if they knew that. But under a lot of the traditional definitions, it wouldn't be a trade secret because it has no inherent value of its own.
I'll quickly address the first one. That I think that, you know, it's a fact-based sort of inquiry as to whether you've taken adequate precautions, and I think most companies do take precautions, and they have, you know, security across the board. Cybersecurity and physical security is really important to most companies, and they think they do a decent job. It's not the kind of thing like the secret formula for Coke, which has to be locked in the vault and only 2 people. Like, that's not required. And so you can have, I think, a fairly decent showing with much less than that, but the normal things of access controls to the place where the you know, data is kept, you know, physical controls to who gets into the building, physical, you know, access controls to who gets onto the network. All of those things I think are perfectly adequate. My sense is that courts are not really holding companies' feet to the fire in any dramatic way on that. I don't know if you.
Well, and there certainly have been cases where maybe the information wasn't well protected, or maybe there was like a 2-year restriction on use and disclosure, and a lot of people signed agreements to that effect. And so here we are 5 years down the road, and the question is made, the assertion is made, you didn't protect the information. I was talking with a litigator recently who said in a case she was involved in, she had to prove what happened and didn't happen with everybody who'd signed the not very good agreements. And so that was the focus of a particular case. So, but on the other hand, if you discover you did something not so great before, that doesn't mean we shouldn't try to protect it now.
Well, and I think it's a litigation strategy, right? I mean,
Yeah.
it's a way to turn the tables, and so it is often raised as litigation strategy, and you have to just get through it. So it is often there in a case, but frankly, it's a strategic.
Yeah, and I think the DTSA, for example, says you have to take reasonable measures, so we all know what reasonable means. It's like I said, fact dependent.
And the issue about the dead ends, I mean, there are plenty of cases saying knowing what not to do can be as valuable as knowing what to do. There's a thought that the DTSA really does protect that. You know, there's a question of remedy. Are you going to order the person to do the thing that doesn't work? No, that probably the best you're going to do is seek an order that the person not be involved in a decision-making process where they'll be deciding whether to do option A, B, C, or D, because they know that one is going to save a lot of money. So perhaps they should be removed from the process altogether.
Great. Well, I think that's all we have time for, but please join me in thanking our panelists for sharing their insight with us today.
All right, I hope everyone enjoyed the first panel and found it informative and interesting. Thank you for those who stayed behind for the second panel. For the second panel, we have a new set of panelists who are experts in the next topic, which is finding the balance between the transparency that people deserve when algorithms used in government decision-making, especially such as when the algorithms used in criminal convictions against the people, and the property interest of proprietary algorithms of for example, private companies. So, Chris?
Yeah, thanks, Brian. First off, before we start, I was told to remind everybody that the event will end promptly at 7:45. Please stay around and chat as you see fit. But CLE registration requires your feedback form, and that whole process ends at 8. So try and get that done right away so that you get the credit that you deserve for being here. Okay, and since I'm on a time constraint, might as well jump into it. First off, I want to thank everybody for sticking around, and I also want to thank our lovely panelists. So going down the line, we have Hannah, and Hannah is she's at Yale, both a fellow and a researcher, and she has worked in the past on one of the cases that we're going to talk about that's pretty important for the algorithm panel. Next in the middle, we have Andrew Subs, who is at the Data and Society Research Institute, right? And he brings a unique perspective on an understanding of the tech side of this, the implications it can have, and truly the nuance of how hard of a problem this really is. When we talked on the phone, it was not only a learning experience for me, but it was in depth, and I enjoyed that a lot. So I think we'll have a good talk on that front. And last but not least, of course, at the end is Rebecca Lipman at the New York City Legal Department, who will, I think, give an interesting side. I'm sorry, I feel like this is so far away. From that perspective. So again, thank you all for joining us. Of course, we're here to talk about algorithmic decision making in government, and that's, I mean, when it comes to bleeding edge topics, I don't think that there's anything that is really more of a bleeding edge topic. With each and every day, algorithms are controlling more of our lives, whether we know it or not, and it creates a whole new sort of conflict where on one hand there's the desire for transparency and the desire for accountability, right? People want to know how the decision that affects them has been reached. But on the other side, on the other hand, there's companies, there's people making these algorithms, and there's IP rights that, as a society, we've always wanted to protect. It's been a long-standing thing in our culture, in the legal process. And so, before we get too far into things, I just want to talk about what we're really facing here. And I figured, Andrew, I'd go to you for this, if you can give an outline of what we're talking about and why the accountability issue is such a hard question to answer in a straightforward manner.
Yeah, thanks, Chris. And first, let me say thanks to the Trade Secrets Institute and Brooklyn Law School for having me. It's really a pleasure to be here and be able to talk about these topics. So I'm just going to go through a few types of systems that governments around the country, city governments, state governments, are using sort of predictive models for. So on the criminal side, we have predictive policing. So it's used to try to predict high crime areas, and often resource allocation to try to figure out where to send police officers. There are also algorithms designed to predict recidivism risk. So these will be used to set bail or parole, or figure out if people pose a risk if they get parole. And we also have cases of algorithms being used in prosecution for forensics, for like DNA matching, which I'm sure Hannah will talk more about. Outside the criminal space, risk assessment is still a big goal. So algorithms are being deployed in child protective services to figure out if a child is at a risk of abuse. The recent New York Times Magazine story, I think, we talked about this algorithm in Allegheny County in Pennsylvania. Resource allocation is another one. So you'll see automated decisions regarding how children are matched to school preferences, or who's eligible for public housing, or other forms of public assistance. Other government functions, particularly at the federal level, require data mining machine learning algorithms because they're looking for patterns over massive quantities of data. So the IRS uses algorithms to figure out who to audit and what patterns of cheating on your taxes looks like. And as everyone probably knows, the NSA and other intelligence agencies use a lot of algorithms to try to figure out who a terrorist might be. We have algorithms where government acts in more private capacity. Hiring screening is often, or resume screening is often done for public and private hires. And there are other kinds of things that that private companies would do where government shares functions, and they would use algorithms. So really, they're everywhere. Almost any decision you can imagine might be made by an algorithm. Now, what are the kinds of transparency and accountability issues? Well, one of them is actually, I don't know how to answer that question in a complete way, because a lot of these algorithms are just kept secret. And so, so they're not publicized. Like, no one knows how decisions are being made, that there's an algorithm at all. A lot of cities rather, have agreed to non-disclosure agreements with companies that they purchase these decision-making tools from, and then when you FOIA the tool, they tell you, well, we can't do anything about it because of the NDA. But we also have a problem besides secrecy of what really transparency means. So a lot of people for a while were talking about algorithmic transparency as if we want to see the code. Now at this stage, I only know one person that keeps talking about it that way. But really, and the reason for that is because source code isn't tremendously helpful in terms of accountability. For one, you need a fair bit of expertise to really understand source code, even if that expertise can get you there. In the last panel, we talked about how hard it is to remember like huge volumes of code. Well, imagine looking at it for the first time and attempting to weed through it. It's basically impossible. What's interesting is you'll often hear about trade secrets as an objection to turning over actual source code, but it's sort of a straw man. Like, nobody wants the source code in many cases. There are some cases, again, as we will hear, where the source code is really helpful. But aside from the code, so maybe we want operational transparency. Maybe we want to know what the algorithm does, right? Trade secrets also come up here, but they seem less important, right? Because you're just being told in words what this thing is doing. The bigger issue for me is gaming. So if everyone understood exactly how tax auditing algorithms worked, no one would pay taxes. Well, some people would pay taxes, but a lot fewer people would pay taxes. And of course, the NSA isn't going to disclose how they generate their terrorist watch list. And there are a couple other, I don't know how much time I should keep going. So my current research is focused on more things like explanation. So when you start talking about algorithms more, people talk about machine learning and really complex algorithms that a person can't process. So it's not a matter of looking at source code, it's a matter of even if you had all the rules and all the different ways that the variables the interactions the variables have, you wouldn't really be able to simulate it in your head what's going to happen. And really the benefit of machine learning, of these massive pattern matching tools, is that they can detect patterns that go beyond what humans can really intuit on their own. So that will generate all sorts of practical problems with accountability. And now you get past some of the problems beyond transparency. How do you predict what an outcome will be? How do you know that it's treating you fairly, like in a non-discriminatory way? Is it challengeable? If you can't understand it, how do you challenge it? It becomes hard to regulate and square with our intuitions about due process. And so the last thing I really want to talk about is the part of algorithms that's not actually algorithms. Data isn't neutral, right? And algorithms are not created in a vacuum. So models have developers, and those developers' priorities and values end up encoded in the model. There are all sorts of unavoidably subjective choices that designers have to make. What are you trying to predict, and why? What data do you collect, and why? Often it's a matter of cost, or inability to collect better data that ends up with a worse algorithm. What features do you look at, and why? Are some types of data simply off limits? How do you manage trade-offs like cost, fairness, interpretability, and accuracy? These are all questions about the ways background values and policies end up shaping the predictive model that results. But when people think about transparency, they rarely think about the humans behind the algorithm. And a lot of the issues with accountability for algorithms are actually that the algorithms are encoding policies that we would otherwise find objectionable and need to be challenged. So in law, we have all sorts of normative concerns, and as algorithms are taking over society, they're all implicated. That's anti-discrimination, due process, privacy, free speech, antitrust, any number of other issues that surround the algorithmic society. Each of these concerns is affected by each of the transparency issues, all the different kinds I talked about a second ago. Each has more to do with the model's design than in what domain it's applied. So all these transparency issues affect like all these different areas of law, but it doesn't matter if it's banking, or maybe I should say there are different issues in banking than there are in the criminal justice system, but they are, the transparency and accountability issues are implicated in all different domains.
Right, and if I, sorry, not to
No,
cut you off,
that's
I just
all,
want to
yeah.
jump in there. And given the fact that this is such a broad issue, right, it's easy to see how in the complexity there can be so many problems, right? And then, but it's not just companies and the private sector tackling this, like you mentioned at the end, it's the city too, and that's, so Rebecca, I want to bring you in, if you can, I'm curious to hear from you, what, the city obviously wants to use these algorithms, right? They're like very important tools, and they provide all these benefits, despite the risks. So how does the city tackle this sort of problem? Where do they use algorithms, if you can speak to that? Of course, if I'm encroaching on anywhere that you can, just let me know. Yeah, that's my first question there.
Absolutely. So thank you for having me here. And this applies to every answer I give tonight. I'm just speaking here in my personal capacity, not as a representative of the city. And some of my answers are cabined in terms of not giving up any privileged information. But I'd just like to say Andrew gave a really excellent summary of the many, many, many aspects to this problem. And in terms of how the city handles it, you know, all of that, I believe, it sort of exists in the background, but at the same time, they're just pressing operational needs that the city has, whether it's deciding how to allocate children into different schools or how to distribute police officers across the city, or much more mundane things that happen on a day-to-day basis. So we'll probably talk more about this later, but in terms of the algorithmic accountability bill that was passed in December of last year, one thing that came up at the hearing was the fact that the original bill as introduced was so broad in scope, it would have basically captured every algorithm the city uses. And there was testimony to the effect of it would be almost impossible to actually study all of these different algorithms, given how many agencies we have across the city, how many sort of minute decisions are made. And I would note, not usually made by the algorithms themselves. It's not like something is just spitting out an answer and that's accepted and there's no humans looking at it. Often algorithms are utilized as a way to help someone make a decision. This is particularly true in the criminal justice context that Andrew touched on. For example, if you're trying to decide whether or not to set bail for someone or how much to set bail, that's a situation where an algorithm might give you an idea of where you might want to set bail, but it's only going to be one of many things a judge would look at. So I would say, going to your question, it's something where the city does use algorithms in a fairly comprehensive way, but it really is spread out across agencies. It depends on the problem they're trying to solve, and it's not always used or developed in the exact same way. It's really kind of problem-specific, agency-specific, and I think changing over time as the technology advances and as algorithmic transparency is something that's getting a lot more attention.
Definitely. So with that in mind, let's talk a little bit about one such tool. We're going to talk about that FST, and Hannah will talk about, in the case USB v. Kevin Johnson, right, you moved to publish the code for the FST. That's the forensic statistical tool was used by New York City. It was used to analyze crime scene DNA, and essentially it was released under protective order, and then Hannah, right, and her group moved to push against that and have it published, and I won't speak to why, the idea behind that, I'll let you do that, but you were successful in that. So what was the mindset behind that, the goal, and
Sure.
yeah.
So I think it's helpful just to understand a little bit of the background to the Johnson case before I get into the motivations for why ProPublica wanted to move to unseal the source code for the FST. In a way, you can't really understand the FST without understanding the sort of premium that the criminal justice system places on DNA, right? There's this idea that DNA is this objective truth about whether someone is guilty or not. And so in the mid-2000s, the city starts to develop this tool to interpret DNA samples called the FST. And it's particularly designed to, for very small DNA samples, to be able to interpret what the likelihood ratio, right? The likelihood that a suspect is a contributor to this DNA sample. And then they introduced the fruits of that sort of interpretation as evidence in a series of criminal cases. And there's a series of cases in which the criminal defendants say, well, in order to understand this evidence, I need access to the source code to understand how this tool is really operating. And in state cases, they're denied time and again, right? There's a series of state cases where criminal defendants seek disclosure and are denied. Along comes Kevin Johnson, who's arrested at his ex-girlfriend's house and charged with possession of 2 guns. The guns are the DNA samples are run through the FST, and one of them comes out that it's like 66 million times more likely than not that Johnson contributed DNA, and the other it's 156 times more likely. So already we see a giant disparity between these 2 samples and the fruits of this interpretation. And Johnson is a federal gun possession case. And so we're in federal court, not state court, and federal judge doesn't feel bound by this line of case law suggesting that Johnson shouldn't get access to the code. Johnson says, I need access to the code in order to mount an effective defense. And there ensues this tug of war between the city and the defense in this case. The city says, can you give it to us or Johnson says, can you give it to me in discovery? City says, no. Can you give it to me in response to a subpoena? No. Finally, the code is made available to Johnson's attorneys pursuant to a protective order. And so they then retain an expert who concludes that the code is indeed flawed. That expert report is then made available to the public on the court docket, but in highly redacted form. So there's no way to understand what the flaws are in the code without understanding what the expert report says, and indeed what the code itself actually says. And that's where ProPublica's interest really stems from, right? So a reporter at ProPublica, which is a nonprofit news organization, has been following this case, and this is the only case in which the code has actually been produced to the defense. So we moved to unseal the code, to lift the protective order. We argued that there was no good cause for it to remain under seal. And that was ultimately successful, in part because at the point where we moved, the city agreed with us. There was no longer any reason for the code to remain under seal, for the protective order to be in place, and the code was made available to ProPublica, which immediately published it on GitHub and wrote a story about the flaws in the code. So I think there are a couple ways in which this sort of story is a little bit different from the ones that we've sort of come to expect about trade secrets in the context of the criminal justice system. And the first is that this is not a proprietary tool. This is a tool that was developed by the city itself, by a city agency, by city employees. And so there really wasn't a trade secret claim as such in the case. There was an asserted proprietary interest, but it's not quite the same as when a private company makes the code available subject to a license or a contract to the government. This, to my knowledge, is the only case that has arisen in this context where it's actually a government agency that developed the tool itself. And the second way in which this case is a little bit different from what we've come to expect, is that it's not the defendant who ultimately is seeking the disclosure of the code to the public, it's a press organization. And the reason for doing so is the press's interest in understanding and interpreting for the public whether or not this code is functioning as it's alleged to or as it's supposed to. And the reason I think that this is important goes back to what you were saying earlier, right? Source code's not helpful because most people can't understand it. I think that it's true that most people can't understand it, but I don't actually know that that's the point of publishing code, right? Like, I think that there are a set of people in the position that ProPublica is in, or that all of the many commenters on the code after it was published can sort of offer their own opinion and analysis of this tool, which they were previously prevented from doing.
Okay, yeah, we'll definitely come back to that. I don't want to jump right into that yet. Before I do, Rebecca, I want to bring it back down to you and just ask, so a case like Kevin Johnson, again, I don't know how much you can talk about it, but at a high level, how does the city view that? How do they view protecting their proprietary interest in a circumstance like that when it's a tool that they've created?
Yeah, so I can't speak to the specifics of the case itself. My office did advise the Office of the Medical Examiner who developed the tool is a client of ours broadly. But I would just say it's interesting, I think, for our debate, the fact that the city is in a very different position when it has developed the tool itself. As Hannah said, there's not really a trade secrets issue here. So the City of New York, because we are so large, we are in a position to sometimes develop our own algorithms. I would say that it's important to remember New York City government is huger by an order of magnitude than most city governments in the country, which is something that I only grew to appreciate once I was there. I mean, for example, my office alone is over 800 lawyers. The equivalent office, even in a good-sized city like Philadelphia, I think is about 40 lawyers. So we have resources that other cities don't. So it's important when thinking about transparency just to keep in mind that a city like New York is going to have resources and therefore products and algorithms that other cities just wouldn't have. They don't have developers. But I think when you do have resources like New York has, it really does open the door to much more interesting discussions about when transparency is appropriate. Because we do have that option. We have the option, as we exercised in this case, to just say, you know what, go ahead and make it public. Where if we were a smaller locality, or again, there are situations where we license algorithms from other companies, our hands are tied by the contract. So people might want transparency because it's the City of New York using a certain algorithm, but that doesn't change the fact that that's somebody else's intellectual property, and we don't get to just ignore the contract under which we're licensing it. So that's one thing to keep in mind. And then I think going to the other aspect would just be the fact that, sorry, I'm losing my train of thought a little bit here. But with algorithms like this, there is a real interest in transparency, I think especially now, and then there can also be sort of policy developments within the city, as Hannah was saying, sort of initially there was resistance and then there wasn't resistance. There's always that possibility in any city government for positions to change over time and for people to become sensitive to certain issues and for that kind of thing to develop and for there to be more processes put in place and more interest over time in thinking about, you know, if we're going to be doing X with Y algorithm, is that something that maybe in New York we want to go ahead and develop that ourselves? Maybe we want to develop it with, you know, outside organizations' input, with advocacy groups' input or academics' input to make sure that once this algorithm is affecting the public, there's that option for transparency to the degree that we might want it.
Yeah, definitely. And I wouldn't be surprised if both the city and everyone involved has their view on this change as algorithms become more prominent, as we discussed, and understood better. Okay, let's open up the floodgates of accountability. So Andrew, we talked on the phone, like I mentioned, about whether or not openness is sufficient, right? And Hannah, you spoke to that when you were talking about the Johnson case. And this is one instance where it was a fundamental liberty at stake, right? It's something that society has always deemed important, and we continue to deem important for good reason. Is there a better way to dealing with openness dealing with accountability that is independent from openness, independent from whether or not the code is actually released?
Yeah, so I kind of want to talk about two different things. Both of which are not, submitting the code, publicizing the code. Though there are still situations where publicizing the code does work. You do get experts to analyze it. There are methods in computer science that have developed over the last decade, really, to rectify the sort of a problem of code not being explainable, or not code, but models, predictive models. And I should say, the algorithms being deployed right now, people talk about algorithms pretty broadly, but a lot of them are pretty simple, are a couple different features that people look at and assign points. If you look at the compass, well, actually I don't know about compass, there was another one. Anyway, a lot of like the risk assessment and bail kinds of algorithms are actually easy to understand. The more machine learning driven algorithms with the huge data sets, huge number of features, those are the ones that are really complicated. Eventually the software will get better, everything will be this machine learning, including what governments are using. So it's really important to sort of break that down. But the first thing I want to talk about are the interpretability issues. So there's been a focus in computer science to try to get methods to make these kinds of models, if not overall understandable to how they reach a specific decision. And I want to talk, without going too much in the technology, let me tell you, one person's research is focused on an actual case that happened where a machine learning model was trying to predict risk of complications from pneumonia in a hospital. This researcher, it's Rich Caruana, he's at Microsoft. He is advocating for globally interpretable models because what this model predicted is that if you're an asthmatic, you are particularly low risk for death from pneumonia. And what was interesting is that in the data, this was true. But what the model didn't figure out was that, because it wasn't shown it, was that the reason was really because asthmatics monitor their breathing a lot. And so they're going to go to the emergency room much more quickly if they have trouble breathing. And asthmatics are incredibly high risk. So when they get to the hospital, they'll be treated like they're high risk and they have better outcomes. They have much less risk of death. But what the model tells you is don't bother going to the hospital, you're fine if you're an asthmatic, which is crazy, right? So he comes in and says, we need interpretable models because we need to see this. And in general, a lot of the work on interpretability focuses on this idea that what will happen is the reasons will come up and we can use domain expertise or overall intuition to tell whether it's gone wrong. And that works sometimes. It works in the obvious cases. And a lot of the times, the reasons will be either really good, like, I can't think of one off the top of my head, or really bad, right? Like, clearly this asthma thing was wrong. Or if you have a model that clearly is just discriminating based on race, that's probably not a model you should be using. These are things that are obvious, but often you'll get from machine learning results that are just strange, that you don't really have an intuition for. And what this explanation method focuses on is something that actually relies a lot on human intuition, which can't be brought to bear in the cases where machine learning is most useful, those that go beyond human intuition and what we can figure out. So, something else I've been advocating for is actually algorithmic impact statements. And they're based on environmental impact statements from, environmental law in the 70s. They've been copied at federal, state, local, and international levels. So impact statements are all over the place right now. And I mean, I want to adopt essentially almost wholeheartedly the environmental impact statement model. So it would be great for a public agency that develops algorithms to examine all the reasonable alternatives to their algorithms, to like talk about what is going to happen with each of these, to consider not adopting the technology and what the difference would that be, or how that would make a difference, to indicate the preferred version of the draft before opening it up to public comment, and to investigate possible mitigation measures for things that have gone wrong. So I think a lot of the things that were the problems with the FST model might have been able to, might have been figured out if there was an impact statement where they had to actually think, oh, what is the data we're collecting and how will that affect it? Do we have enough data to truly make this assessment? Those are the kinds of questions. So in general, I see three purposes to impact statements, which is why I really think they're important. The first is to get agencies to do their homework. The problems with a lot of algorithmic governance is simply thoughtlessness, or lack of accountability for people with decision-making authority, or lack of technical expertise. It's not really malice a lot of the time. It's a lot of the time you have cash-strapped departments, like police departments, where a third party comes to them and say, hey, we got your cash problem, just buy this technology and you'll figure out, you'll reduce your police force in half. And no police department's gonna say no to that. But what happens is they don't shop it around, they don't really have the technical expertise to interrogate it. What an algorithmic impact statement would require is that they actually find some or work with a state agency if they're a city. The second would be publication, right? So this gets at the transparency and not of the algorithm, but the people's decisions and the decision process. So remember how I said earlier that a lot of the worry is really a question of how models are opaquely substituting for policy judgments over a wide range of issues? Well, this is the solution to that, right? You're publicizing not necessarily the algorithm, but the process, the decisions that went into the algorithm. As Rebecca said, why did you choose to develop it in-house or buy something? Why did you choose to solve this with technology as opposed to some other way? Those are really important questions. And the last thing is about public comment, public engagement, right? A lot of the same issues that are causing the need for an algorithmic impact statement to begin with, the lack of technical expertise, the lack of essentially care, are remedied if you do something, you say, hey, this is what we did, and then you open it up to the public. Like, imagine that happened with FSD. I imagine ProPublica would be like, hey, come on, there are some issues with this, go fix it. And public comment, public engagement, since we're all, it essentially makes it a communal enterprise, right? The idea with government is that it's supposed to be actually helping its community and involving its community. It doesn't want to come up with these oversights, so why not invite the community in to actually talk? And so these are really the purposes of algorithmic impact statements. Now, a truly obstinate department that is really just going forward might not care and might, see the comments and say, well, we're not going to change anything. But I imagine most of the people in this space are good actors and would actually want to improve their model if they had the expertise, if they had the resources to do it. And so using the community would actually be really helpful. So those are my general ideas. There are other ideas out there about technical ways to, rather than legal, like something called discrimination-aware data mining. There are all those kinds of solutions. Audits are another one, but I don't have time to talk about that.
Yeah, so on the legislative side now, we see the accountability bill, right? New York City is sort of on the forefront in that regard, I'd say. And so the bill basically is setting up a task force that's going to monitor fairness and validity of algorithms used by the city, right? And so, Hannah, first with you, I'm curious to hear how you feel that task force is going to work. What do you think about Andrew's proposed solution? Do you think that it's in line with what you pushed for in Kevin Johnson, for example, or is this steering us in a new direction?
I mean, I think the task force sounds great. I think algorithmic impact statements sound great. I don't think they're enough. And here's why. I think any situation in which you are, and I should say, I litigate freedom of information cases as a job, so maybe I have a distinct perspective on this. But when you put the obligation on the city itself to explain what it's doing and to sort of self-justify the choices that it's made, I think it inherently raises some questions about whether you're getting enough information, whether you're getting all the information. And so I'm sort of curious about why not have disclosure of the algorithmic tools? I think the underlying reason is that in this sort of shift toward evidence-based practices in policing, in schooling, in the criminal justice system, you see more and more a host of proprietary tools being used that are simply better than what cities can come up with, more accurate than what most cities can come up with on their own. And the result of that is that cities are sort of in a bind. This isn't just New York. I mean, I think it's true of many different governments, that they're in a bind as to they want the best tools available, but they can't really adopt them in a way that makes them adequately understandable to the public. And so this solution is a sort of stopgap, right? Because it allows the city to make available some information, but the public still can't know whether it's getting all the information. There's an element of this that's about trust in the system to provide the right information, which maybe I'm just a cynic. But I also think that this is particularly problematic where algorithmic tools are substituting for human decision-making that the public previously had access to and could understand. So in situations like bail, where previously a judge would just make a decision, we've shifted to the use of algorithmic tools in some settings that either sort of supplement and justify what the judge is doing, or that sort of stand in for what the judge is doing. And as a result, it's much more difficult for the public to understand that decision-making process in a lot of different contexts. And that poses a broader problem for public accountability, and it's not one that I think you can rely on the government to solve itself. It's one in which I think the adversarial relationship between the public and the government in this context is actually important and fruitful in determining what kinds of disclosure are really essential.
Yeah, Rebecca, I would imagine that you have a different perspective coming from the city side. I was wondering what sort of considerations went into this bill. I would imagine that the city is thinking of these things just as we are. What were the main focuses, and do you think that moving forward, the bill will accomplish the goal that we're trying to serve here?
Yeah, sure. Well, first to respond briefly to Hannah, I think with algorithms, it's important to remember there's certain ones that are going to be high profile, and then certain ones that are just sort of going to be workhorses of city government operating at a very low profile that nobody's making much noise about. So bail is a situation that is really high profile, and rightfully so. I mean, we're talking about people's liberty here. And I think the benefit, again, especially in a city the size of New York, there is that opportunity to try to really get things right and try to really be open about it so people do understand these decisions and they don't feel like anyone should ever have to stand up and say, well, I'm going to jail because an algorithm said so. So in an effort to gather a couple things tonight to make sure I wasn't telling you privileged stuff, I actually have a quote handy from the director of the Office of Criminal Justice inside the mayor's office. And this is something they're looking at right now. And she's talking about specifically what they call their failure to appear tool, which is used in these bail decisions. And she said, the big change for us is really to just make the process as open as possible to ultimately post the data that underlies the tool publicly so that people can see for themselves how the tools operate. And some of that data is actually already available. So that's a space where I think actually when there is this sort of level of public attention and public interest, again, rightfully so, you actually will get pretty good outcomes. And even cities that are not New York might be able to benefit from this kind of public attention because I think they're fairly large nonprofit organizations that are also interested in developing tools. So that's a third option I didn't mention before. Obviously, you can have cities buying stuff, or licensing stuff rather. You can have it developing it themselves. But they're also, if they're large enough sort of good actors, nonprofits out there, they're also somebody who can create a tool that they make completely transparent. So I think, at least in that space, for the high-profile stuff, you can be in good shape. Turning to the bill, I would say, yeah, so there was a lot of concern about this. This is a bill that originated in the city council. I think I actually just looked over the hearing transcript, and the chairman was very pleased. He said it was the largest crowd he ever had for a meeting of the Committee on Technology. And again, rightfully so, lots of interest, lots of advocacy groups, academics, just folks very interested in this issue as people get that algorithms are having more and more of an impact on their daily lives. And as Chris was saying, the bill as ultimately drafted creates a task force, the mayor appoints it. It creates recommendations for a few different things. First, it somewhat controls the scope of which algorithms are actually going to be focused on, because again, like I said, if the city tried to make transparent like every single algorithm they use, it would just be a deluge of data up to the point, frankly, where it probably wouldn't be terribly useful to anyone, and would just, the size of the administrative burden would be outrageous. There's sort of a subset of tools that people are really interested in. Again, tools that affect people's rights, tools that distribute benefits in some way. It's not literally every single thing that helps somebody make a decision at city government. So they'll go ahead and decide kind of the scope of the task force as an initial matter. And then they go ahead, and the next couple of things are procedures where they're trying to look at what is the algorithm doing in terms of potentially creating some sort of disparate impact. Because that's obviously something you don't want to have. So that's not like, nobody's going to design an algorithm saying like, oh yes, make sure there's like, this algorithm gives more to white people than black people. Like, that wouldn't happen. But on the other hand, there is a concern out there that because of the underlying data, Andrew might want to talk to this a little bit more, that an algorithm could unintentionally act in a biased form. So one of the things the task force will look at is trying to figure out, is this having an impact that we didn't intend to have? And then if it is having that kind of impact, what are folks going to be able to do about that? And a couple other things in there are also just like helping people who are affected by an algorithm understand how. Again, attempting some kind of transparency, developing recommendations where there can potentially be some kind of procedures as through which a person affected by a decision concerning a rule, policy, or action implemented by the city where such decision was made by, or again, with the assistance of an agency automated decision system, it's the wordy version of algorithm in this bill, may request and receive an explanation of such decision and the basis therefore. So I think that's a really interesting part of the bill. It's, again, this is a task force that's going to see what kind of procedures like this are going to be possible. So it's hard to know what the task force will ultimately come up with, but that, again, that's kind of what the council was thinking about, and then I was part of the administration team working on some of this language, so it's where the council and the mayor together were sort of trying to get the bill to go in terms of really trying to figure out what's at the heart of a lot of this concern about algorithms. Again, understanding, if possible, if it's not like a total black box algorithm, why did this decision happen? Why was I denied benefits? Because I think, especially here, as the legal audience, there's just a sense that, like, in due process, you should be able to say, why did this happen? And have some sort of answer besides a computer said so. So that's one of the things the task force will look at. And then the last thing deals with making things public and also archiving algorithms to the extent practicable. So they'll have some time to study all those things and ultimately deliver a report and make recommendations, and we'll see where it goes.
Perfect. So, Andrew, I'm going to close out with one I can't talk right now. Sorry. Substantive question, and then I'm going to ask for all your opinions on a couple things, but we're sort of getting close to time. I want to leave some time for questions as well. But I know you were involved with the initiative pushing for this task force, I believe, and I'm just curious to hear from you what you think the goals of the task force should be, and if you think that they can accomplish those goals in a way that does maintain trade secrecy or proprietary rights to the best of their ability.
Well, actually, I mean, thanks, but I should say that I was watching from the sidelines. It seems like half the people in the U.S. that are doing research on this area are in New York. And so, weirdly, I don't know, New York has a decent tech scene, but it's just odd. So the fact that this is happening in New York City, there was a lot of traffic between us talking about things afterwards, and the hearing itself had like 3 hours of witnesses. It was pretty both absurd and amazing. But yeah, I mean, I don't know what the task force can do. It hasn't convened yet. Nobody knows who's going to be on it. Nobody knows. The recommendations are not binding on the mayor or the city. So it's unclear what ultimate effect it's going to have, but it's also just unclear what recommendations it can have. It's got an 18-month window to study the effects of algorithms, a lot changes in 18 months. 3 years ago, people weren't really talking about algorithms that much in terms of a due process, in terms of fairness, and now it's, you know, one of the biggest topics. At a major computer science research, or a major computer science conference called NIPS in San Diego, Kate Crawford gave a talk about the fairness of AI to 8,000 people. It's insane. It couldn't have been imagined. And so, I don't know what happens in 18 months. Maybe a lot, but maybe for the task force. It's hard to say.
Okay, yeah, and then I guess we'll go down the line. So the closing question is, given all of the things we've discussed, given what we, the city, we as a society are doing to try and protect these fundamental liberties in some circumstances, or accountability generally, do you think that we can pull it off and come to some sort of program where we can have accountability and some proprietary rights, or are we doomed in some circumstances where things have to be fully black box, for example? I know it's a little
We're
bit
doomed.
not to be the cynic as well, but
You know, I think rightly a lot of the discussion about transparency in these contexts has focused on how to make these tools accountable to the people who are most affected by them. So accountable to criminal defendants, accountable to the communities that are policed. And I think that one of the ways that we can ensure meaningful accountability in this context is by not putting the burden only on the sort of people who are most affected by these tools to try to gain some clarity and understanding into how they function. In other words, I think there's a really meaningful role for the press and the public to play in ensuring that the government discloses enough information that its own decision-making processes, its own policies can be accountable to the electorate functionally. And so I think that is a way of ensuring meaningful accountability that I don't think has been sufficiently explored, certainly not in the sort of scholarly debate about transparency and interpretability.
same question, hopefully in like 30 seconds or less sort of thing.
Okay, I'm good at that. I have mixed feelings. There's a lot of really good research being done on this, but research is research. We have a governance problem in this country. Cities are actually doing fine in a sense. The state and federal governments, we may or may not be able to tie our own shoes, let alone tackle the most difficult technology policy problem of probably all time. So I have doubts on that. And also, with how hot a field it's become on the technical side, I'm a little worried because I think some of the answer might turn out to be that there are domains we just should not use this tech, like for reasons of being black box or whatever. But the more it becomes a tech-dominated question, the more it seems like it's a technology problem with a technology answer that just hasn't been found yet. And we need more of the lawyers and the policymakers to be engaging in this discussion before it gets out of before we lose the ability to actually have that be a potential answer.
Yeah, I just wanted to quickly separate out two things because your question kind of framed it in two different ways. One being trade secrets, sort of the topic of the day here. That feels more solvable to me, you know, if we decide that, at least for the algorithms that are really important to us and important in a social justice way, we want that to be something that, you know, governments or nonprofits develop. That seems like sort of a decision that could happen, at least in some parts of the country, to be like, yes, this is something that will be sponsored by organizations where they can share this information. But then the next part of the question is, can the algorithm be designed in a way where it's truly transparent? Because we haven't explained much technical stuff to this crowd, but like a lot of algorithms, especially the better ones, work based on machine learning, where the algorithm is teaching itself in a sense, so that maybe you started out knowing how it was making its decisions, but a month or two in, you don't know how it's making those decisions anymore. You literally cannot explain it, not because it's a trade secret, nobody knows. which is a little bit scary, but also like how really sophisticated algorithms actually work. So I think then you get into a really interesting debate of like, well, do we want to keep the algorithms dumber so it's always explainable? Or there's a really interesting piece I read just the other night. It was out of Harvard's Berkman Klein Center, which does great thinking on this. You know, is it enough to, if we know what the algorithm is optimized for? You know, that could be one way to say like, okay, we don't need the source code, we don't need to understand 100% how it's making these decisions, but do we know what is it optimized for? You know, is it optimized for some sort of fairness that we care about? Is it optimized to just hire, you know, who it thinks are the most qualified people, even if that gets you like 100% white male pool? You know, it's like knowing some of the decisions that went into designing the algorithm, could that be enough? So I feel less like we're doomed on that front. I feel like there's a lot of like interesting conversations ahead. So those are my two reasons for some optimism. On the trade secrets front, I don't think this necessarily has to be IP, at least for the really important stuff. I don't think it necessarily needs to come from a private company. And then on the technological end, I think there's just a lot more conversations ahead, and it's not going to be easy, but there might ultimately be some sort of middle ground that we end up feeling comfortable with as a society, where we don't know everything, but we know enough where we can satisfy sort of our traditional legal and ethical values. That would be the hope.
Perfect. Well, I'm sure that there's a ton of questions. Unfortunately, we don't have the time, so please stick around, and I hope that you all can as well. Join me in thanking our panelists, both. Again, a quick reminder, please hand in your CLE materials before 8 o'clock, right back there. And thank you all for joining us.
So I want to add one more round of thanks,
that's fine.
just to
I
intrude
ran
right at the
time.
end. So,
Ran time.
of course, to our excellent panelists, also to the BLS event staff, to Liz Alper and to Dasha Tanner for managing the event and managing the CLE. And then finally to the fellows. I'm the faculty advisor to the Trade Secrets Institute. It's a really sweet gig because it mostly consists of getting out of their way. This is really an event that they conceive and they organize. And once again, as every year, I'm fantastically impressed by the way they pulled it off. So certainly thanks to them.